the state having arrested Mr. Jameson, do you need some time to confer with your client?
I have conferred with my client,
Alright.
and we will go over that in a minute. At this time, I would like to make a motion directing verdict not guilty and have the court rule on that.
Alright, you may do so, sir.
I would ask the court to direct or instruct a verdict of not guilty
Based on,
the state failing to prove up probable cause and would waive additional argument.
alright, overruled.
At this time, by way of admonishment, I have spoken with my client, and do you want my client to be sworn, Judge?
Oh, if you want him on the record to make a record of his decision whether to testify or not testify.
Yes, I do want my client to know that on the record.
Mr. Guzman, if you would, please raise your right hand. Do you solemnly, well, your other one, there you go. It's okay. Do you solemnly swear or affirm that the testimony you're about to give in this hearing outside the presence of the jury will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you can put your hand down, thank you, and you may be seated.
Yeah, your name is Alexander Guzman. And Mr. Guzman, you understand that as a person on trial accused of an offense, you are not required to testify. Now, we have discussed this, and this is completely your decision, and I understand it is your decision that you do not wish to testify. Is that correct?
Yes.
I agree, and I support that decision. That would be my recommendation, not to testify, because if you chose to testify, you could be impeached, and these fine attorneys would certainly ask you about other matters that we do not want the jury to hear about right now. Now, additionally, I need to know whether or not you're satisfied with the representation.
Yes, that's right.
Thank you. Is there anything else that you would need for me to do that I have not done? Now, we did discuss, the plea offer. The plea offer was 50 years. It was your decision to reject that, so you didn't want to plead to 50 years, is that correct? And your decision that, we would, take this to trial. So this would conclude the admonishment, Judge.
All right, thank you, Mr. Jameson. Does the defense have any witnesses to call in your case in chief, or do you intend to rest as well?
No, we intend to rest. Should we get to punishment, we anticipate there may be some supportive family members that may wish to say something.
Certainly. I just wanted to know so that we can go straight into closing arguments.
I believe the charge is appropriate with respect to the Fifth Amendment.
Yes.
Yes.
Thank you. The failure to testify or choice not to testify is included. All right, then I'll give you 5 minutes to prepare your arguments, and then we'll bring the jury back in.
Thank you.
Thank you. Yeah. Something sounds like a cricket. Yeah.
of that information. Was not happy.
Yeah, there's two different breeds that will be hatching after 15 years of hibernation.
That way we don't walk with it.
All right, y'all ready?
Yes, Your Honor.
Okay, let's bring the jury in.
Yes, you are.
Thank you, sir. We're ready.
All rise.
You may be seated. All right, the state having rested, what says the defense?
Defense rest.
All right, both sides closed.
Close.
Close, Your Honor.
All right, ladies and gentlemen of the jury, you've now heard all the evidence that you are going to hear in this case. I stayed late last night and drafted the court's instructions to the jury. I will now read this to you, but you do not have to memorize it. This court's charge will go back with you to the jury room. After I read you these instructions, we will then have arguments of counsel. Court's instructions to the jury. Members of the jury. The defendant, Alexander Guzman, stands charged by indictment with the offense of aggravated robbery alleged to have been committed on or about September 17, 2023 in Dallas County, Texas. To this charge, the defendant has pleaded not guilty. Offense definitions. A person commits the offense of robbery when, in the course of committing theft, as that term is herein defined, and with intent to obtain and maintain control of property of another, intentionally or knowingly threatens or places another in fear of imminent bodily injury or death. The offense is aggravated robbery if the person committing the robbery uses or exhibits a deadly weapon. Term definitions. In the course of committing theft means conduct that occurs in an attempt to commit, during the commission, or in immediate flight after the attempt or commission of theft. Attempt to commit an offense occurs if, with specific intent to commit an offense, a person does an act amounting to more than mere preparation that tends but fails to effect the commission of the offense intended. Bodily injury means physical pain, illness, or any impairment of physical condition. Theft, as used in these instructions, is the unlawful appropriation of property of another with intent to deprive such person of said property. Appropriation and appropriate, as those terms are used in these instructions, means to acquire or otherwise exercise control over property other than real property. Appropriation of property is unlawful if it is without the owner's effective consent. Property, as used in these instructions, means tangible or intangible personal property or documents, including money, that represents or embodies anything of value. Deprive, as used here in these instructions, means to withhold property from the owner permanently. Effective consent means assent in fact, whether express or apparent, and includes consent by a person legally authorized to act for the owner. Consent is not effective if it should be induced, there's a typo. If induced by deception or coercion or force or threats. Owner means a person who has title to the property, possession of the property, or a greater right to possession of the property than the person charged. Possession means actual care, custody, control, or management of the property. Intoxication means disturbance of mental or physical capacity resulting from the introduction of any substance into the body. Deadly weapon means a firearm or anything in the manner of its use or intended use is capable of causing death or serious bodily injury. A firearm is per se a deadly weapon. Mental state definitions. A person acts intentionally or with intent with respect to the nature of his conduct or to the result of his conduct when it is his conscious objective or desire to engage in the conduct or cause the result. A person acts knowingly or with knowledge with respect to the nature of his conduct or to circumstances surrounding his conduct when he is aware of the nature of his conduct or that circumstances exist. A person acts knowingly or with knowledge with respect to a result of his conduct. Party liability. A person is criminally responsible as a party to an offense if the offense is committed by his own conduct, by the conduct of another for which he is criminally responsible, or both. Each party to an offense may be charged with the commission of the offense. A person is criminally responsible for an offense committed by the conduct of another if, acting with intent to promote or assist the commission of the offense, he solicits, encourages, directs, aids, or attempts to aid the person to commit the offense. Mere presence alone will not constitute one a party to an offense. Application of the law to the facts. Now, bearing in mind the foregoing instructions, if you believe from the evidence beyond a reasonable doubt that on or about September 17, 2023, in Dallas County, Texas, the defendant, Alexander Guzman, acting alone or as a party, as that term has been defined herein, intentionally or knowingly, while in the course of committing theft of property and with intent to obtain or maintain control of said property, cause bodily injury to another, Ricardo Servin, hereinafter called complainant, by shooting complainant with a firearm, a deadly weapon, and the defendant did use or exhibit a deadly weapon, to wit a firearm, you will find the defendant guilty of the offense of aggravated robbery, and so say by your verdict. Unless you find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will acquit the defendant and say by your verdict, not guilty. Fifth Amendment right. Our law provides that a defendant may testify in his own behalf if he elects to do so. This, however, is a right accorded a defendant, and in the event he elects not to testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever as a circumstance against him. Instruction regarding an indictment. A grand jury indictment is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence of guilt, nor can it be considered by you in passing upon the question of guilt of the defendant. The burden of proof in all criminal cases rests upon the state throughout the trial and never shifts to the defendant. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that he has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt, after a careful and impartial consideration of all the evidence in the case. Burden of proof. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. The burden of proof in all criminal cases rests upon the state throughout the trial and never shifts to the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt after considering all the evidence before you and these instructions, you will acquit him and say by your verdict, not guilty. Limiting instruction. You are instructed that if there is any testimony before you in this case regarding the defendant having committed other offenses, wrongs, or bad acts, if any, against the complaining witnesses, other than the offense described in the indictment in this case, you cannot consider said testimony for any purpose unless you find and believe beyond a reasonable doubt that the defendant committed such other offenses, wrongs, or acts, if any were committed. Even then, you may only consider the same in determining the state of mind of the defendant, motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake or accident of the defendant, if any, in connection with the offense alleged against him in the indictment. Evidentiary instruction. At times throughout the trial, the court has been called upon to pass on the question of whether or not certain offered evidence might be properly admitted. You are not to be concerned by the reasons for such rulings and are not to draw any inferences from them. Whether offered evidence is admissible is purely a question of law. In admitting evidence to which an objection is made, the court neither determines what weight to be given such evidence nor passes on the credibility of the witness. As to any offered evidence that has been rejected by the court, you, of course, must not consider the same. As to any question to which an objection was sustained, you must not conjecture as to what the answer might have been or as to the reason for the objection. Instruction regarding bias. You are instructed that jurors must be able and willing to make careful and impartial decisions that are not based on bias or prejudice. Do not let any personal bias, prejudice, sympathy, or resentment on your part, or any such personal emotion on your part, enter your deliberations or affect your verdict in this case. All persons deserve fair treatment and equal justice under the law, regardless of their race, national origin, religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic. You must set aside your own personal biases and prejudices during your deliberations and base your verdict on the evidence. Decisions based, either wholly or in part, on unfair stereotypes have no place in a criminal trial and will taint any verdict which is not based solely on the evidence and these instructions. Deliberation instructions. After you retire to the jury room, you should select one of your members as your presiding juror. It is his or her duty to preside at your deliberations, vote with you, and when you have unanimously agreed upon a verdict, to certify to your verdict by using the appropriate form attached hereto and signing the same as presiding juror. Your verdict must be unanimous and shall be arrived at by due deliberations and not by majority vote or any method of chance. It is only from the witness stand that the jury is permitted to receive evidence regarding the case, and no juror is permitted to communicate to any other juror anything he may have heard regarding the case from any source other than the witness stand. You are instructed that any statements of counsel made during the course of this trial or during argument not supported by the evidence, or statements of law made by counsel not in harmony with the law as stated to you by the court in these instructions, are to be wholly disregarded. During your deliberations in the case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider or mention any personal knowledge or information you may have about any fact or person connected with this case which is not shown by the evidence. During your deliberations, you are also instructed you must not communicate with or provide any information to anyone by any means about this case. You may not use any electronic device or media such as telephone, cell phone, smartphone, iPhone, or computer, the internet, any internet service, or any text or instant messaging service, or any internet chat room, blog, or website such as Facebook, Snapchat, LinkedIn, YouTube, Instagram, TikTok, or Twitter, to communicate to anyone any information about the case or conduct any research about this case until I accept your verdict, if any. After you have retired to consider your verdict, no one has any authority to communicate with you except the bailiff who has you in charge. You may communicate with this court in writing signed by the presiding juror through the bailiff who has you in charge. Do not attempt to talk to the bailiff, the attorneys, or the court concerning any question you may have. Your sole duty at this time is to determine the guilt or innocence of the defendant under the indictment in this cause and restrict your deliberations solely to the issue of whether the defendant is guilty or not guilty. If you have a verdict or if you wish to take a break, turn on the red light and the bailiff will quickly respond. Signed by me, Nancy Mulder, presiding judge of this court. The very last page contains the two verdict forms. We, the jury, unanimously find the defendant, Alexander Guzman, guilty of aggravated robbery as charged in the indictment. Or, we, the jury, unanimously find the defendant, Alexander Guzman, not guilty. There's a place underneath each of these verdicts for the presiding juror to sign and then print his or her name. We will now have arguments of counsel. Will the state open?
Yes, Your Honor.
And how much time do you wanna use?
About 5 minutes, Your Honor, if that's all right.
That's fine.
Thank you.
You may proceed.
Thank you. May it please the court, opposing counsel. Good morning. Ladies and gentlemen, September 17th, 2023, not that long ago, should have been a good day. Ricardo Servan should have been able to be with his 5-year-old daughter. He should have been able to sit in his car. He should have been able to talk on the phone to his girlfriend or wife. He should have had that good weekend with his daughter. We have all been there. He was not in the bad part of town. He wasn't out partying. He wasn't with a bad group of guys. He was receiving his 5-year-old daughter for the weekend, just like any one of us. Instead of that happening, this defendant was greedy and violent, and he wanted his car. So we robbed him, or he tried to at least. Ricardo got in the car and he sped away, and the robbery was not completed. But we'll get into how that's still an aggravated robbery, so don't stay on that too long. Goes to the hospital, and DPD starts investigating this case. What do they find? They find a video of the offense. They find a car circling. They find this defendant getting out of the car, and they see him shoot into the car and Ricardo drive away. We continue our investigation, right? We learned from Emily Godinez, the apartment manager, hey, y'all know this just happened last week? And she pulls that video. And what do we see? Same thing. We see that blue Chevrolet Cruze being driven by someone, and this defendant coming out with a gun and firing it. Same exact thing. We continue investigating. The car that's stolen September 8th gets dropped off near where they live. What do you make of that? Very simple. It's dropped off where Franco and Alexander Guzman live. And who do we find on that handle but this defendant's brother? We continue searching. We look at that apartment complex. We see them on surveillance together. We see this defendant wearing that same exact shirt. We see all these things lining up clear. It is not a question of who did what. There is one reasonable, logical solution to this aggravated robbery. Just one. And it's that this defendant committed an aggravated robbery against Ricardo Servan when he was just trying to be with his 5-year-old daughter. That's what happened. Now, if Mr. Davidson gets up here and says, no, guys, the only fingerprint was Franco, so therefore it has to be the brother and it's not Alexander, let's quickly look at the jury charge, right? There's a whole part about party liability. Judge talked about it. We talked about it a little bit on Monday, about how, hey, if you commit a crime with someone, you're both equally guilty. Here is the classic version of party liability. 2 guys go to commit a bank robbery. One guy gets out with the gun and robs the bank, and the other guy's in the getaway car. They are both guilty of aggravated robbery. That's the classic way to teach this. And wouldn't you know it, that's exactly what we have here. Detective Fehrenbach got on the stand and explained, hey, that's how this happens, that's how this works. You want 2 people who trust each other to commit crimes together. You want them to case and circle so that they can protect the other one that's robbing. That's exactly what happens on that video. I'm not going to take up too much more of your time, because this case has been proven time and time and time again to you. It's on video. We have fingerprints linking this family. We have information that this car belongs to a member of this family, right? Because it's Franco's girlfriend's car. Just happens to be. So Franco drives it, Alexander does the robbery, and they drive away. 1 + 1 = 2. And even though the case is simple, and even though we have all this great evidence, it's still incredibly important for y'all to bring this guilty verdict home. Ricardo deserves more. Our community deserves a whole lot more. It's important to hold Alexander Guzman accountable for what he did. Look at how many times he's in that same shirt. It's the same shirt he's arrested in. Could 1,000 more people have this shirt? Of course. It's Under Armour. I'm sure 1,000 more people do. They don't look like that. He's right there. Find him guilty of aggravated robbery. He is.
Mr. Jameson, before you begin, ladies and gentlemen of the jury, I apologize, apparently my copy of the charge failed to print out. Just one brief additional instruction, which I will read to you now. Voluntary intoxication. You are instructed that voluntary intoxication does not constitute a defense to the commission of a crime. All right, Mr. James, and I'm adding that to the charge. Thank you.
Thank you. May it please the court, counsel. My job is ending. I'm doing all I can, and I've done all I can to help this man. Now it's going to be up to you. And it's a tough job. Yes, there is lots of evidence to sift through. There is the presumption of innocence that the judge has instructed you about. I don't necessarily envy your job, but if we could all agree on what the facts are, if we could all agree on what the disposition would be, then we wouldn't need you guys. You are the conscience of the community. You are the protection from the government of the individual accused. Now we'll talk about your burden and duties in just a minute. What do we know about Franco? Well, yes, Franco had a warrant for his arrest. For what? Aggravated robbery. So, he's arrested. He is interviewed by Detective Fehrenbach. This interview goes on for, say, an hour, hour and a half. Purpose of the interview is not to talk about the Dallas Cowboys or whatever their season was doing back in September, but to talk about robbery offenses. The interview went on for a period of time. It is only a reasonable deduction from the evidence that that interview would continue as long as it was productive for the detective, getting the answers he wanted, the answers he needed. Now, these are smart attorneys. I know them. You know, I deal with them on a weekly basis. There are ways to bring in statements of co-defendants, procedures you have to go through. They know that. The court knows that. But what they have not done is they have not brought you that interview. They have not brought you that co-defendant. Now, you can only assume there is no specific evidence as to what Franco said in that particular interview with respect to his involvement or anybody else's involvement for that time. Franco, yes, had the Chevy Cavalier. That was his girlfriend's car. He had care, custody, and control of that. Now, you'll look at the jury charge and it talks about the mental state definitions. It talks about a person acting intentionally or with intent with respect to the nature of his conduct or as a result of his conduct if it is his conscious objective. Now, that guy you apparently saw stumbling around, I would suggest to you that man is not conscious for whatever reason. I mean, is he there, as the police suggest, just putting on an act, or is he really by intoxication or mental deficiency? If he is in fact intoxicated, we don't know whether that was voluntary or involuntary. We don't know whether this other guy, Franco, was setting him up to it, if in fact it was this man. We don't know who was the ringleader, who was the brains behind this operation, if in fact it was smart at all to try to prove, commit these offenses. No, that man stumbling around, couldn't even stand up, had to go brace himself against a truck, that man isn't conscious. Now, with respect to the other mental states, as to whether a person's acting knowingly or with knowledge of the nature of his conduct, is it clear to you that that man stumbling around, does someone really need to pull off an act in order to approach a vehicle? Do they really need to appear intoxicated or voluntary intoxicated? No. Whoever you see on that video, I would suggest to you, does not have a conscious objective and is probably not aware of the nature of his conduct. There is no evidence as to the origin of the firearm. The firearm, was in the vehicle that Franco had the keys to. It was his girlfriend's vehicle. That's where the firearm was. Now, on many cases, and I do this a lot, most of the time juries want to know, most requested item is, we want to see DNA evidence. We want to see scientific evidence. And not just witness testimony, because there can be a fallacy with witness testimony. I mean, here, Freddie Lehi said that his assailant was 6 feet tall, just like me. And if you recall, Mr. Lehi encountered this man standing up. Well, this man isn't 6 feet tall. He was described by the officer as being about maybe 5'5", 5'6", which incidentally is what Ricardo Servan described his height as. 5'5", maybe 5'7", but Mr. Servan encountered this man when Mr. Servan was sitting down. So we got two different descriptions of this assailant. I mean, maybe within a span of 5 days, this man gained or lost 5 inches in height. I don't think so. Now, with respect to fingerprints, juries often want to see fingerprints. Okay, there are fingerprints. And what does the fingerprint evidence tell you? That Franco Guzman's fingerprints were on the door handle of the white GMC Sierra pickup. Now, in the video, they show an assailant entering the white GMC pickup, and yes, obvious, the testimony was he went through the driver door, he touched the handle, he didn't climb to the window, didn't go to the back seat and crawl over, didn't go to the passenger side, open the door and get in that way. The scientific evidence shows that it was Franco Guzman's whose hand fingerprint was on the door handle. Reasonable then that it was Franco Guzman who did that. Now, you can look at this man now and think, who's heavier, who's thinner, or whatever. Certainly people, appearances can change within the span of 6 months. I would suggest to you that being brothers, there is a family type resemblance. Fingerprints. You saw the shell casings. They showed you shell casings recovered being held in a gloved hand. Now, why did they do that? Well, they wanted to, not because the shell casings were too hot or because they were harmful or whatever, but it was to preserve the evidence on the shell casing. You heard testimony about, a Glock weapon, a firearm. These bullets are loaded there is no fingerprint match to this man, the accused, or to anybody. Well, ask yourselves, why in the world are they preserving these shell casings with a gloved hand, if not to connect the fingerprints? Scientific evidence. I asked the officer about a GSR test, gunshot residue, and he didn't even know what that was. There is no scientific test as to whether or not this man had fired a firearm. Now, with respect to the t-shirt, yes, there are probably thousands of these t-shirts. Under Armour's a national brand. I know you can go to a t-shirt shop and, custom design your own t-shirt, but that's a t-shirt he was wearing when he was detained. Not necessarily the same shirt. Could be a coincidence that the person was wearing it. Could be that if these two brothers lived together, it's not a stretch to think that they might have worn each other's t-shirts or whatever. Now, let's talk about the reasonable doubt. Reasonable doubt. Yeah, each of you can have your own definitions and should have your own definitions. I would suggest to you that it is something that you should rely on in your own personal affairs without hesitation. Now, you might have another opinion as to what reasonable doubt is, but what it is not, well, maybe this guy did it. What it is not, well, a little more than 50-50 that he did it. Maybe chance, perhaps he did it, perhaps he didn't do it. That's what it's not. It's not clear and convincing evidence, as we talked about in the voir dire last Monday, which would be the standard if the government was trying to take your children away. It is beyond a reasonable doubt. Now think about it. If Detective Ferrybot gets up here and tells me your loved one is not in that burning house, we have rescued them, then fine, I would act upon that. Now, no disservice to complaining witness Ricardo Servin or Freddie Leyva, but if they were to tell me that, your loved one is not in that burning house, I'm going in. I'm verifying that. Now, maybe you would too. Maybe you would rely on their word without hesitation. Now, this is an important case, not only to the accused, to the community. I don't think you're going to see any mini cams or television reporters. I don't think you're going to have to justify your verdict to anyone but yourself. But if you feel that the state has not proved the case beyond a reasonable doubt, it is your verdict to vote not guilty. As I told you in the beginning, no, you don't have the option of finding this man innocent because he is presumed to be innocent and still is presumed to be innocent until such time as you find beyond a reasonable doubt that he is guilty. Thank you for your time and service.
Thank you, Mr. Jameson. All right, Mr. Grant.
Thank you, Your Honor. Ladies and gentlemen of the jury, the defendant said that you have a tough job. No, you have a tough burden. But this isn't a hard job. Over the course of these 2 days, the state has proved to you evidence beyond a reasonable doubt that Alexander Guzman committed the robbery on September 17th. The evidence is overwhelming. You know, when we started off, I told you you're going to be able to see it for yourself. And we did. In my years, this is one of the clearest cut surveillance cameras that I've had. We have angles all across the apartment complex. And that apartment complex again, is the Cantera Crossing Apartments. It's a big apartment complex, 200-something person unit in West Oak Cliff. Predominantly Hispanic community, a lot of working people, don't like talking to the police, right? So we're looking around, and we have cameras capturing that whole community to protect that same community, right? So what do we see? The first thing that we looked at, we saw that it's a two-person offense, right? Two people, in which the evidence has showed, at least one of them is Franco Guzman, and defense isn't contending that. He said, hey, one of them looks like Franco Guzman, and we know there's two people, only two people live together, two males in the house. Who can it be? So we have them getting dropped off at building 3. That's the same thing that we saw happen on the 8th, right? Same pattern. Somebody drops them off, they go out to commit the robbery. So he walks over in that same blue shirt, and it's that same person. Look at State's Exhibit 7, and look at the defendant. Look at the similarities, not even looking at the shirt. We got a beard, we got a cut, they're the same similar statue. If you were to look at somebody and describe them, you would describe them equally. Because they are the same person. And we're just comparing that to the same shirt. So put that shirt on them, boom, you got them. So what does he do? He continues to walk around pretending to be drunk. Why is he doing that? Because he knows it can work. He's done it before. He did it the week before in the same apartment complex. So how do you get from one side to the other without somebody getting suspicious? Without Ricardo Servan being like, hey, I don't know who this person is rapidly approaching me, I'm just gonna drive away. Oh, you just kind of stumble and sneak your way on up there. And that's what he does. He stumbles, he sneaks, in contact before he does the robbery, makes contact with that person in that Chevy Cruze. He's like, all right, we're good to go, we're doing it. So at this point, we know for sure the robbery's on, they're both in on it. He gets up to the car, reaches into his right pocket, as you see there, reaching down, and pulls out a gun. Windows down, car is off. Points a gun in there, get out of the car, or I'm gonna kill you. And that's what he does. He doesn't kill him, he doesn't get out of the car, but that's what Alexander Guzman does. He carjacks people. We saw the week before. We saw him walk up to the car, reach on the jacket, chase Freddie Lehoff down the stairs, shooting once in the air, shooting once by his feet, taking his $600, taking his wallet, taking his car. And when the other guy's walking away, bam, shoots in that direction one more time, right? He steals cars by force. That's what he does. And he will use force. And that's what we saw. We saw him pointing the gun in there, we saw the lights turn on. Takes Exhibit 51, you actually see that muzzle flash. You see that gun go off. And remember, we looked at the photos inside the car. We saw that little bullet hole in the passenger seat. That's from that. We know it's Ricardo Servan, the victim, and we know exactly what happened. So, I guess the only thing we're gonna say is, it's not me, it's Franco. No, they don't look anything alike, first of all. But before we get into that, obviously Ricardo Servan gets into the hospital. He gets shot in the back. We're fortunate the bullet just went through and through. We're fortunate it didn't hit his spine. We're fortunate this is just an aggravated robbery. But it is your duty to continue to bring justice to Ricardo Servan, to Freddie Lehoff, to this community, to Emily Godinez, to Andrea Soto, to everybody involved. It's your responsibility to bring justice because he is guilty. And what did we know from September 17th? Looking at the evidence, we know again, two people in the car. You see one on the left, you see one driver on the right. The person in the passenger seat is wearing this shirt. You see lettering above the yellow logo, right? It's the same shirt. We So, and we know it's a Chevy Cruze, you can see the little Chevy emblem, and you can see that red dealer tag. You can see that dealer tag a little bit better quality here. We also know, again, Chevy Cruze with those tire marks. So, the police compare it again to that same week before, because they're doing what we're doing. We're comparing two offenses to know that's the same guy, because when they looked at it, everything looked to be that same person. So the officers respond to Freddie Leha. You heard testimony from him about what happened. You heard testimony that he was chased down the mailbox, shot at, and had his truck stolen, right? You heard him identify the defendant in open court. That is proof of guilt right there. You saw Ricardo's servant identify the defendant in open court. You saw this proof of guilt again right there. The evidence in this case is overwhelming. So again, you see him shoot right there. Same firearm, 9mm handgun. Again, 9mm handgun used in this offense. Oh, and what was in the trunk of their car? A gun box for a 9mm handgun with a magazine for a 9mm handgun. And what was in their house? In a box, some ammunition for a 9mm handgun. We don't have the gun, but we have everything else but the gun. Again, look at his face. That is the same person that we see on the 17th. That is the same person that we see on October 9th. That is the same person. Just looking at it, you know it is. And we see that person get into the truck. So, and you heard testimony from both fingerprint experts to why sometimes latent prints can't register on something that's taken, right? There could be oil on the fingers, there could be dirt on the fingers. Just me touching this doesn't mean it's going to be a latent print. It might, but it's not a guarantee. But it doesn't get there without somebody touching it. And we know that Franco Guzman touched this car. His fingerprints are on this car, and this car is located in the apartment complex. We talked about law parties, right? It could be one of them, could be both of them. And we know there's two people involved. Only two people fit the suspect, and you saw that photo of Franco Guzman. Him and Alexander Guzman look nothing alike. I mean, I'm all for brother similarities and, DNA and all of that, but they don't look anything alike, and you know that. They're different heights, they're different builds. Look at them. You could see the similarities, but there's no way that you would say that that person is the same person. So, we're looking at other similarities. Again, September 8th, September 17th. Both dropped off in the same location. Both victims say it was him. Looking at the car when they got on October 9th, September 8th, and September 17th. Same car. Same car. Same car. We've got the same thing dangling in the top. We've got that little license plate reader. You saw that video of that thing dangling also on September 8th. It's the same car and all of it. And whose car is it? It's a Guzman's. Not by name, but it's Franco Guzman's girlfriend's car. And we saw them access that car. You saw those videos and those photos from Fugitive. You saw them walking up to the car, taking stuff out. We know they have access to that car. And then that brings us to the shirt. Again, this is the shirt that was recovered from the defendant's body. Detective Fairmont took it off Alexander Guzman. He physically took the shirt off. And this is the same shirt that he's wearing on this day. And this is the same shirt he's wearing on the 17th. You have a tough burden, but you don't have a tough job. Because the evidence here is overwhelming. All you heard today from defense was what's not, what's not, what's not. Oh, yeah, anybody can buy an Under Armour shirt. It's not a custom shirt. But you didn't hear anything saying, oh, that can't be him. All you heard was what's not and what is. And all you need to do is consider the what is. And what he is guilty of robbing Ricardo Servant on September 17th. Thank you.
All right, thank you, Mr. Grant. All right, ladies and gentlemen, I have made those corrections to the jury charge. I am printing that out. You are now instructed to retire to the jury room, select your presiding juror, and begin your deliberations.
All rise.
I'll meet you back there with the jury charge. You may be seated, thank you.
At this time, in the event of a guilty verdict, is it appropriate if we fingerprint the defendant now for a later comparison?
Yes, you can.
Thank you, Judge. I don't think there's
Judge, I'll
anything.
take the bathroom.
Sure.
Take the board off.
Is that
Do the
okay?
photo thing. I'll leave that if you want. I'm not taking it back. They didn't give it us.
He told you I was adding voluntary intoxication and then didn't, so it's now added on the second page. So, let me sign this, get this to the jury, and then I'll be right with you, Mr. Jenkins.
Thank you, Judge.
But first you must pull up pictures of Caroline and Jack so I can see what they look like.
They look a little different these
I
days.
know.
I'll put him in, I'll put him in.
You sure?
Yeah.
I'll take them off.
Okay. Come on.
We're going back.
Oh, Mr. Grant,
Yes, Judge.
here's a copy of the charge. You want to keep it
Absolutely.
for future cases or anything?
I appreciate it. It's one of the few times, like, there's always issues with the charge that I've had. This is the first time I haven't had any.
Oh,
So,
good.
it's really nice.
I'm glad to hear it. Excellent work, by the way.
Thank you.
You're very well prepared. And did a good job.
Turn to that, you're
Sure, come on up.
We across the hall, agreed plea?
Sure. You want to, we can do a plea. The jury just want to,
Okay, I mean, it's up to you, I can take it to minutes.
that's fine.
Okay, let me get a docket sheet and stamp.
No problem.
Thank you, Judge.
You're welcome.
There's Jack and his girlfriend.
Oh, how tall is he now?
He's almost 6'1".
He looks more like you now.
He's looking a little more like me,
Yeah.
except fit.
Well, we all were when we were, 16, 17.
Yeah, it was easier back then, wasn't it?
Sure was. I remember skipping meals, not being hungry.
Yeah. He came
When I
home.
miss a meal, I feel like I'm faint.
He came home yesterday at like 7 o'clock, and he said, "What do we got to eat?" And I said, I said,
That long?
he hadn't eaten all
I
day.
got, like,
He said,
three
I literally
Oh,
haven't
my.
eaten a thing all day, and then he
I'm
ate
trying
like
to
80
not,
pounds
like,
of food all
rip
day.
off, like,
And then he went out to dinner with his
Oh, thank you. Still live streaming. Learn my lesson. There we go. So,
Okay.
girl. And where's he?
He's at Booker T,
Oh, yeah,
and she's at Booker T,
I gotta get
but she's about to graduate, so.
So she's in Elliot's class, Chris Martinez.
Uh-huh.
So what does he do there? Does he do music?
He's ours,
so.
but he's pretty much given up on that.
Yes.
Oh, well, yeah, when he can't. Oh, you can still hear it? Dang it. I'm just gonna stop.